Well, the release of the Twitter files unveiled that the censorship industrial complex is not just a conspiracy theory touted by upset conservatives, but that it's a very real effort by our government to censor Americans with differing opinions. In this country, the United States of America, land of the free, our government worked in collusion with big tech to silence legitimate viewpoints, many viewpoints now known to be actually truthful. Luckily, there were some that were working to hold the Biden administration accountable. A landmark case brought forward by the attorney generals of Louisiana and Missouri is doing just that, and they're actually winning so far. What they're doing in Missouri versus Biden could amount to the biggest class action lawsuit against the administration and a major win for free speech. Here's Assistant Attorney General of Louisiana, John Sauer, testifying to Congress about some of what they found in their discovery of the case.
Last July, the plaintiffs in Louisiana and Missouri against Biden received a limited discovery of communications about censorship between federal officials and social media platforms. What we obtained was astonishing, staggering, and horrifying. A veritable army of federal officials pressures, threatens, coerces, colludes with, demands, and deceives social media platforms to censor online speech. Our evidence shows White House officials badgering social media platforms in private to censor speech that contradicts the White House's preferred narratives, while the president publicly accuses them of, quote, killing people by not censoring enough of ordinary American speech. And the president's spokespeople raise the specter of crippling legal consequences if they don't comply. One major platform responds to White House demands by assuring them, we hear your call to do more, and it scrambles to carry out, quote, what the White House expects from us on misinformation going forward. Our evidence shows federal officials routinely flagging social media posts by ordinary Americans for censorship. It shows federal officials orchestrating elaborate plots of deception to dupe platforms into censoring disfavored speech. It shows federal officials engaging in seemingly endless meetings with the content moderation officers of major platforms to discuss disinformation and censorship. It shows federal officials serving as privileged fact checkers with effective authority to dictate what Americans can and cannot say on matters of immense public importance on social media. And it shows federal officials relentlessly pressuring social media platforms by threatening them with ruinous legal consequences if they do not cave to the federal demands for censorship. Truth is not the goal of this federal censorship enterprise. The censors have been proven wrong again and again, including on politically seismic issues. But each time the censors are proven wrong, the censorship has continued unabated, and it expands. And that is because now, as at every other time in human history, the goal of censorship is not to promote truth. It's to obtain, preserve, and expand political power.
Some of the plaintiffs' names mentioned in Missouri versus Biden include Dr. Jay Bhattacharya of Stanford, Dr. Martin Kulldorff of Harvard, and Dr. Aaron Kheriaty, who was the director of medical ethics program at UC Irvine before he was fired for saying mandating the vaccine is unethical. You can't make this stuff up. He recently released a new book, The New Abnormal, and is here with us now to give us an update to the Missouri versus Biden case. Dr. Kheriaty, it is great to have you on the show. Thank you for being here.
Great to be with you again, Kim.
So there's an update to this case. A lot of these cases have not made it very far.
Right.
But you guys are actually making some real progress on this, what would be potentially a landmark, I think, censorship case.
That's right. The latest news on the case from last week is that the judge denied a request from the government, from the defendants in this case, the federal agencies. They submitted what's called a motion for dismissal, saying, for various reasons, various arguments that they put forward, that either we don't have standing to bring the case or we don't have sufficient evidence to bring the case. And the judge rejected basically all of their arguments and said, no, all of the plaintiffs, both the two states, Missouri and Louisiana, and the private plaintiffs, myself included, do have standing to bring the case, that in our initial complaint and other documents that we've submitted to the court, we've presented sufficient evidence to warrant the case moving forward. So basically, the judge has green-lighted the case to go to trial, which means we've gotten over a lot of challenging and difficult hurdles that some other cases that have been brought forward in the last year or so to try to challenge the censorship industrial complex and the federal collusion with social media companies haven't been able to surmount. So this is a very positive development for our case, and we're looking forward to taking the case to trial and continuing with the fact-finding process and cross-examining the government's witnesses, and all the additional information that's going to come out during the trial, I think, is going to be very helpful to continue characterizing the anatomy of this censorship industry.
Yeah, that's amazing. So, do you know when this is going to be going to trial? Do you have any ideas yet?
So I don't know. I don't think we have an exact date yet for the beginning of the trial. A lot of the stuff in federal court is hurry up and wait. So I don't have any updates on that, at least since I last checked a few days ago. But it probably at this point will be soon that we'll get a date on the calendar to begin the trial process.
So you're going up against the government. So the Missouri and Louisiana, and you and a few others are the plaintiffs in the case, and you are suing the U.S. government. Is that right? Is it a lawsuit?
That's
How do
correct.
these work? Okay, so it's a suit.
So
Yeah.
it's a lawsuit on constitutional grounds, right? And one of the government's arguments was that they have what the law calls sovereign immunity, meaning you can't sue the government for various things. But in this case, our suit is based on the highest law of the land, which is the First Amendment of the Constitution of the United States. The judge made it very clear that government agencies, government officials, even the President of the United States himself, is subject, like we all are, to the Constitution. And so because we're bringing a constitutional claim in federal court, we are able to sue the government in this case. Obviously, it's a bit of a David versus Goliath because the government has infinite resources to sort of throw at this thing. But we believe ultimately that the fact-finding process in federal court, if it's conducted in a fair manner, and the judge so far seems very inclined to be fair in this case, that the truth will come out and we'll get a favorable ruling.
So when you sue, what are you suing for?
Basically, we're suing to disarm and dismantle any collusion, any collaboration, any pressure coming from the government to the social media companies or to any other publishers. And the court, we're hoping, is going to intervene and say the government can no longer do this. Now, how that is going to be enforced is going to be an interesting legal question, because one of the defendants in the case is the Department of Justice. I mean, the defense is basically the executive branch of the government. There's, at my last count, at least 11 different federal agencies named as defendants in this case. And so how the court's ruling is actually going to be enforced, I think is a challenging question in this case, when the branch of government responsible for enforcing court rulings is the defendant in this case and is part of the problem in this case. So whether the court's going to ask for an independent commission to be set up, whether Congress is going to have to intervene with ongoing investigations to follow up and make sure that the court's ruling is actually applied. I don't know the answer to that question. I'm not sure anyone knows the answer to that question, but we are hoping this will be the beginning of the end of the censorship industrial complex, which has been growing and developing since around 2016, 2017.
Yeah, it does seem like it would be very difficult to figure out exactly what the recourse would be for you, because yeah, we could say, well, the government shouldn't have any sort of discussion with these social media companies, but at the same time, they sort of have to on some things. Actual crimes that are being committed, so they do need to have some communication with them. But then, yeah, it's like, how do we?
No, you're absolutely right. Like, the key issue in this case, and the government's central defense, is that we're not pressuring, we're not coercing, we're not cajoling, which we have lots of evidence that they were, but we're just trying to be cooperative. We're just flagging things and bringing forward that information, and social media companies can do whatever they want with it. That's clearly not true, but that's their defense. But even if that were true, Kim, when it comes to censorship, that can still pose a problem. The court in the latest ruling from last week cited 5 different ways that the government can be unconstitutionally involved in censorship. So everything hinges on the question of what constitutes what the law calls state action. Is the state actually acting to censor private speech here? And the first of those 5 ways is the use of coercive power, the kind of bullying, the kind of the kind of abuse and threats that have certainly occurred and that we've uncovered in some cases. For example, I wrote a piece in the Wall Street Journal called "The White House COVID Censorship Machine," and in there, one of the attorneys in the case and I explain the communications that we got undiscovered between a man named Rob Flaherty, head of digital communications at the White House, and a senior executive at Twitter. And that was definitely an emotionally abusive relationship and an attempt at coercion. But even setting aside the worst and most egregious examples of coercion, the court said the state can't provide significant encouragement, either overt or covert, to a private action. Even more subtle attempts to influence that action can be problematic. Even when the private actor is acting as a willful participant in a sort of joint activity with the state and the two are intertwined, that can be problematic. That can be a matter of state action. So this various forms of subtle entwinement with government policies sort of operating in the background. And then other situations in which the state either overtly or even, doesn't have to even overtly threaten punishment in the form of regulation, but just knowing that the government could remove things like Section 230 protection that indemnifies social media companies against certain forms of liability. And if that was removed, that would be totally ruinous for a Facebook or a Twitter. Even having those factors operating in the background without direct threat could be problematic in terms of implicating the state in censorship. And in our case, we have the president, we have members of Congress stating very overtly, if you do not do what we want you to do, if you do not do more in terms of censorship, we're going to remove those Section 230 protections. And we cite all of that evidence in our complaint. So I think in our case, the court clearly recognizes that in all five of these ways that can be problematic, we've presented evidence so far that the government has run afoul of the Constitution and has been engaging in illegal activity. And the other important thing to understand about this case is just the scope and the breadth of what's happening. So that testimony you cited earlier from John Sauer, he sort of opens with a couple of examples to illustrate what we're talking about here. He says, for example, imagine a world where White House officials email the New York Times editorial board about a story criticizing the president, and they abuse the paper in profane language. They threaten legal consequences if they don't remove the story, and the paper complies. Well, that's essentially what has happened between the White House and Twitter. He says, imagine a world in which the FBI emails a list of books to booksellers that it wants banned, and the booksellers comply by burning at least half of the books on that list. Well, that's essentially what the White House and what various federal agencies, and indeed what the FBI has done with Facebook. Finally, he says, imagine a world where the Department of Homeland Security teams up with Stanford University. He doesn't name DSH and Stanford, but that's what he's talking about, to establish a mass surveillance program of ordinary Americans' thoughts and opinions. And it utilizes swarms of analysts and cutting-edge technology to covertly censor millions of social media posts. That's not just an analogy. That's, in fact, exactly what's been happening and exactly what we've uncovered in Missouri v. Biden and in the Twitter files. So prior censorship cases usually dealt with one publisher, maybe with one publication or one article or set of articles. What we're talking about here, Kim, is millions of examples of censorship. And we've never seen a censorship case dealing with so many specific violations of the law, in part because this is the first major censorship case of this kind implicating the government of the digital age, and just the power of social media, the power of the algorithms, the power of the armies of researchers that the government had at its disposal to flag content is something that, prior to 10 years ago would not have been possible. So I think this case is going to turn out to be very, very consequential, not just because it's dealing with novel technologies, but because so many individual Americans have been impacted by this censorship, not just a handful or a couple of writers here or there who weren't allowed to air their opinions, but literally millions of ordinary Americans.
Yeah, that's absolutely right. And that is what the Twitter files definitely exposed. I'm curious. So it seems you did definitely use a lot of the Twitter files as evidence in this case. Have you had the ability to go after other social media companies? I am dying to see the YouTube files, quite frankly. Many of us were censored from
Yeah.
YouTube. Would love to see the Facebook files. Would love to see other social media companies dug into on this, and maybe that would be part of the lawsuit. Is there a way, or is there a plan to, I guess, do that sort of discovery in those different social media
Yeah, that's a
outlets and
great
not just Twitter?
question. Yeah, the Twitter files are the tip of the iceberg, and Twitter might not have been the most egregious offender in terms of cooperating with the government or colluding with the government on censorship. And in fact, most of what we presented in the case, we got prior to the Twitter files being released. So most of our discovery, most of our depositions, most of the documents that we obtained on subpoena, we got before any of the Twitter files were released. I think there was a bit of overlap between the first few installments of the Twitter files and the final documents that we submitted before the court's recent ruling. So I think what we've seen with our case in the Twitter files is plenty of overlap, but actually two now independent sources of similar kinds of information, each one confirming what the other one is saying. And if this case proceeds forward, hopefully there will be more opportunities to subpoena additional information from Facebook, from Instagram, from other social media platforms. And I'm also hoping that this case will open up more lawsuits of this kind to challenge maybe specific instances or specific social media companies on specific issues. I think the Twitter files are the tip of the iceberg. In a sense, as much as we've uncovered on Missouri v. Biden, I think that is still the tip of the iceberg. We're beginning to get a sense of how all of that machinery was set up, how all of that was working. You saw Michael Schellenberger and Matt Taibbi testifying a couple of weeks ago in Congress, talking about their research and the research of Mike Bentz over at the Foundation for Freedom. So there's a lot of people now working on this issue to try to figure out what's going on. But again, there's just been so much of it happening that there's an endless supply of examples of violations. And I'm hoping that will lead to a tidal wave of lawsuits that will ultimately take down this censorship regime, because it needs to be dismantled. This is a very, very serious problem. And our little experiment in American democracy is not going to survive unless this censorship industrial complex is dismantled soon.
Yeah. No, you're absolutely right. You're absolutely right. And I'm so glad you guys are taking this up, because it has been apparent for a while that this was absolutely a violation of the First Amendment. A lot of people for years have been screaming, saying, no, these are private companies. These are private companies. And I would always point out, how, if the government is saying do this or else, how is that private company working on behalf of themselves and their own best interests? These private companies have it is not in their best interest to censor all of these people. It is not in their best interest to take content down that a lot of eyeballs are seeing. They're not doing that in their own best interest. It's good for them to get millions of eyeballs, right? They're doing it because the government is saying to them, do it or else you're going to suffer. We've seen them dragged into congressional hearing after congressional hearing, questioned by lawmakers, and essentially threatened by lawmakers, do something or else. And it sort of started with Facebook's Cambridge Analytica. We saw that happen, and they were carted in, and then it was like one by one. We want to know how the Russians did it. And that's how they started off, and then it's just grown into this massive, now a giant scandal of censoring Americans. And many of those Americans who had very much, especially during the COVID years, we've seen many with that, like Jay Bhattacharya and Martin Kulldorff with the Great Barrington Declaration, ended up being where we're at now. And it's like, so it's unbelievable that we are living in a world like this right now. And I'm glad you guys are I'm glad that you're taking this up as a First Amendment issue against the government. I hope that these social media companies actually join in on that. I would think that Twitter itself, Elon Musk, has a case to say the U.S. government was basically strong-arming my company into censoring people on my platform, and they were threatening me if I didn't do it. I don't know. So that I feel like they should join in on these cases. They have
I
the money,
completely
the power,
agree.
the lawyers.
Yeah.
Right.
Yeah, that's right. I mean, they should be able to tell the government to back off. But when the government is carrying such a big stick,
Yeah.
they're put in a position where it's almost impossible to do that. I mean, we know now that the FBI was cultivating very senior executives at Twitter in the same way that it would that it would cultivate an intelligence asset, right? That these people were really instrumentalized and put in the government's back pocket in ways that were, very sophisticated and actually quite
Yeah.
evil is the only word I can think of for it. And I think maybe just one more point on why this is important. The Supreme Court has made it clear that when censorship is occurring, it's bad enough that the person being censored is harmed, right? Because my opinions can't get a hearing. That's unconstitutional. That's not okay. But the Supreme Court has also said the First Amendment of the Constitution, free speech rights, exist not just for the speaker, but for the listener, for the
Yeah.
receiver of information. And so all Americans were adversely affected by this
Yeah.
censorship regime because all Americans were subjected to the control of the flow of information by the government and were led to believe, for example, that there was a scientific consensus on lockdowns, speaking of the Great Barrington Declaration, when there was no such consensus. It's just that voices, credible voices, Paul Bhattacharya and Sunetra Gupta at Oxford, were silent and sidelined, set aside. So this is, this is something that all Americans, I think, should care about, because all Americans are potentially adversely impacted when anyone is censored. You don't have to be someone that's posting a lot of things on social media to be concerned about this. You could be
Yeah.
someone who just wants, gets a lot of your
Information.
news.
Yeah. It was essentially a great cover up is what they were doing. And that's a crime. If you cover up and you omit information, that is, so Dr. Aaron Kheriaty, thank you so much for being with us today. Really appreciate you joining us. I think we've lost you a little. Oh, there you are. We keep losing you a little bit here.
My screen froze up there. Sorry about that.
Okay. Tell us real quickly about your book, The New Abnormal, The Rise of the Biomedical Security State, which is also something very scary to think about.
So what I call the biomedical security state, which has been developing in the background 20, 25 years, but we saw it fully manifesting during the pandemic, is this welding of three things that used to be distinct. The first is an increasingly militarized public health apparatus. The second is the use of digital technologies of surveillance and control. And these two things are backed up by the third element, which is the police powers of the state. I say that we saw this manifest more fully during COVID, but I argue in the book that COVID was just the beginning, that this infrastructure that was rolled out is still in place, ready and waiting for the next declared public health emergency. And so the book is really about the future. Is where is this thing going next? Looking at the next steps in the process of rolling out new mechanisms of control, things like digital IDs tied to biometric data, central bank digital currencies that will allow for the monitoring of all financial transactions. So the book is an attempt to help ordinary Americans understand not just what happened to us over the last 3 years, but what's going to continue to happen to us if we don't recognize that these new mechanisms of surveillance and control and increasingly powerful technologies are going to be continually deployed against ordinary citizens if we don't recognize what's happening and start pushing back and reclaiming our freedoms.
Yeah, well, we all should read it, even though it sounds really dismal to read, quite honestly. But you're right. We should be prepared. We should be prepared for what it is that they're going to be rolling, because they are doing this. They are rolling this out. And they're actually being pretty blatant about it. They're just right up front and saying, yeah, we're going to do this. We're doing this to you.
That's right. Yeah.
So good to know about that. So thank you so much for joining us, Dr. Aaron Kheriaty, author, The New Abnormal. Thank you, and good luck with that case. We'll definitely be following it, that Missouri versus Biden. Thank you.
Thanks.